I get this all the time, and a lot of times it's from civil lawyers, and a lot of times it's from just lay people or clients. They all think that, hey man, all you got to do is show a reasonable doubt. How hard is that? I mean, anybody can walk in and show a reasonable doubt. Yeah, the numbers will tell you not so much. So the reality is, in state court, Aaron, 94 to 97% of cases end up in a plea, right? A guilty plea. In federal court, it's even higher. 98 to 99% end up in plea bargains, right? Those are very tall numbers. The rate of conviction in trials isn't any better, right? So if you go to trial, it varies state by state, but let's say of that 3% or 5% that didn't plead guilty, 75 to 85% of that 5% get convicted when they go to trial. In federal, it's even more substantial. The conviction rate is 83 to 90%, right? Do the math on that. You're talking about 3%, and of those 3%, 97% often get found guilty. So your acquittal rates are infinitesimal, right? It's very, very, just from a sheer statistical analysis. This doesn't mean that everybody's that guilty, for lack of a better description. I'm simply pointing out to you the numbers, right? And the numbers are overwhelmingly in favor of the idea that A, people are going to plead guilty, or B, if they try the case, they're going to get convicted. The odds are not in your favor as a criminal defendant. So when I hear, oh, it's no big deal, all you got to do is go in there and raise a reasonable doubt. Well, look at the numbers, Hoss. The numbers are not good. And people say, well, why are the plea rates so high? The first is it's just systemic pressure and practical realities, or the biggest part of it is just the practical realities. If you go to trial, most times you're going to get what's called a trial penalty if you lose, right? You're going to get a more severe sentence from the judge than you otherwise would get through a plea bargain. There are resource constraints. In other words, prosecutors are highly incentivized to make plea bargain offers. If every defendant in every courtroom said, I want a trial, the system would collapse. It can't support that, right? Because it's built on the idea that people are going to plead guilty. It's built on the idea in federal court that not only are people going to plead guilty, they're going to cooperate against other people to get them to plead guilty or to help the government fines. You have mandatory minimums and sentencing guidelines. You have pretrial detention, right? So if your client is in jail for a year or 6 months or 18 months, he is highly incentivized to plead guilty to get the hell out of jail, right? It's a far more likely result that he's going to plead guilty if he's already in jail. Okay, so in Texas, statistically, you have the best odds in two kinds of cases. One, assault charges. There's only about a 45 to 50% conviction rate, right? So that means about 55% is going to end up in an acquittal or a dismissal. DWIs, they have only a 70% conviction rate, which means you've got a 30% acquittal rate. That doesn't sound like much until you overlay it over the other ones, right? Where you've got a 98% conviction rate. And I think that you got two reasons for that. Number one, assault charges and DWI charges, those are baby prosecutors, right? You got a prosecutor who is 6 months out of school or a year out of school or 2 years out of school. We have some very good DWI lawyers in Houston and in Texas, and I'm not taking anything away from their skill set, but some of these guys, I've won 15 in a row or I've won 20 in a row. I'm like, well, good for you, right? You've been practicing 20 years and you're teeing off against a baby seal, right, who's had six months of trial work. You should be winning, because the odds are very much in your favor compared to the other cases. I'm not taking anything away from the DWI lawyers. We've got some really good ones here in town, but the odds in those cases, assault cases and DWIs, are better than the more serious charges.